Good afternoon. Another fun day in the Social Security world. Had a question from a fellow, and it happened to relate to something that just happened today, so I thought I'd share it since it's kind of like a twofer. Um, he points out, and this is in response to a recent video put out where we describe how the SSA and the ALJ puts an exertional limit categorization on you, also known as part of your RFC, your residual functional capacity. And in that video, I go into it as to what those limits are, so you know what they're talking about. And this gentleman points out that the SSA doesn't seem to say anything about the RFC, residual functional capacity. And there are videos about that. I think you can even look up a playlist, I think called residual functional capacity, on my channel. But that they don't mention when they deny you, they don't say, well, we found you to have this residual functional capacity, and therefore, here are the jobs you can do. They don't tell you that in the letter. It is ultra vague. You probably know I have a brief playlist on the kind of canned letter paragraphs you're going to find in a denial by the SSA on initial or reconsideration. It is very different when you get an ALJ denial. An ALJ denial is far more professional, I'd like to say, far more legally based. As the ALJ, whether you agree with the ALJ's conclusion or not, each finding that the ALJ has to make to come to a conclusion of either disabled or not within the relevant time frame has to be backed up with specific pointers to specific medical evidence that's found in the exhibited file that was exhibited prior to your hearing. So it's a very different ballgame in terms of explanation. And again, that's whether you have a favorable or an unfavorable result. But this viewer, James, thank you, James, was so spot on about the RFC not being in the SSA's denial determinations. They're actually, it'll say disapproved up in the upper left, or but those are known as determinations, whereas an ALJ conclusion is noted to be a decision. He rightly points out that the denials are vague. And at what point, he asked, does the lawyer see what the RFC is for their client? What was assigned to their client? So this was so well taken because it's true. We do not know on initial or reconsideration. So like when you're denied on initial, the letter's not going to say it. And what they allow us to see in the ERE, Electronic Records Express, I think that's what some people refer to also as the electronic file, or maybe they abbreviate it to EF. We don't get to see that. When you're denied on initial, we don't get to see it. When we file for reconsideration, we still don't get to see it because that's in that realm of the lower levels of the SSA, and they are very, very stingy with what they let us see. Not as stingy as they were before 2020. So it's come a long way, but it's still too stingy because I think we should be able to see that all the way through. Okay, so when do we first get to see it as attorneys? We get to see it after you've been denied the 2 times and you've appealed for a hearing with an ALJ. Then we get to, once we get into that ALJ file, which should happen pretty fast if we've already been connected to your file as an appointed representative way before you had to appeal for ALJ, we should see it pretty much right away. I would like to think within days of appealing. And then we can see, and that would be in section A, which we don't normally see until ALJ denial. ALJ hearing has been requested because we don't get to see it on recon denial or on initial denial. So that's when we can find what is called the disability determination explanation, DDE. And there's one on initial produced by the SSA, and there's one on reconsideration. I presume it's the adjudicator that creates it. And within there is the medical expert that was part of the decision, the medical expert down below. who, after the adjudicator gathered all the medical evidence, all your visiting, your treatment records, if you went to any consultative examinations, he shuffles that off to a medical expert who then decides what your RFC is. And that RFC will likely determine the outcome of your case at that level. And again, we can't see it at that time. Now, I put out another video on the 3288, which is a form in which a person can request their file from the SSA. So sometimes it is not a bad idea, particularly if you're pro se, to request that file from the SSA, which would be from the field office. As of now, I'd say they have a very, very poor handling of those requests. Even though the request form is actually one of theirs, there is also some misinformation on the request form where they deny a certain ability to get you your whole file, which is contrary to the law. So that video I have on that about getting your file, you might want to look at. It also provides you a rebuttal to when they say they can't give you your whole file, because we have the actual program operations manual section for that we like to present to them when they come up with this false information. So what happened today on my side, separately from James' share, on a case where I had a partially favorable recently, and it took like 2 years. It was on reconsideration. They give them the win, contrary to what happened on initial, but in a way to not offend initial, they did not give him an onset date of when he alleged, but much, much later. In fact, in this case, they pegged it on when he turned 55, which meant no back benefits. That was about $80,000 worth of lost back benefits, maybe a little bit less. So he thought long and hard. We went over the risks of appealing, because there are risks of appealing. I think that's in a different video. And he decided he wanted to appeal because that was far too much money to not appeal for, particularly when he knows he could not work after he stopped a year and a half, 2 years prior to what they say. And he was treating the whole time as well and had a surgery even. So I didn't think it was a horrible idea to appeal, particularly when he was really well apprised of the risk. And so that is what we ended up doing. But prior to doing that, let's say he was on his own. And in fact, I wanted this too. Since we couldn't see the reason for the poorly chosen established onset date that is contrary to our alleged onset date, because we're not allowed to see anything prior to appealing to an ALJ hearing, we submitted on behalf of the client. So it was the client telling the SSA, please send my file to this attorney. And it's on the 3288. So time is flying. This was sent a few months ago, probably, or a couple of months ago, maybe. And you have to decide whether you're going to appeal within 60 days. So you can't really sit around and wait for the field office to get off its tuchus and get you these things. So we ended up deciding to appeal anyway, because we do know what evidence was in the file. We don't know why they chose a different onset date, but we do know what's in the file. So we went ahead and appealed the client as per his wishes. In the meantime, today I get a letter from that field office saying, here's a bill for $40 if you want to get that file from us. Now I have the POMS that says it's free, 1 copy for program purposes. So I smacked back I will say I was pretty sharp. And I don't mean brainy sharp. I mean like sharp tongues, because I was extremely annoyed. And I went in the letter, I went into the fact that they are just wasting everybody's resources, taxpayers, their own office, by setting out this, not providing the claimant with his file as he properly requested. It explains in there the exact program purpose. He has an outstanding claim. That's a program purpose, people. So I explained that. I explained how they're wasting taxpayer money. If they're they're supposed to be very busy and understaffed at that office. Why on earth are you wasting time sending me a bill instead of sending him his file as requested? you're also now potentially wasting the Office of Hearing Operations staff time, because we had to go and appeal without knowing because if we found out looking in there, the DDE, it was a really, really strong reason why they gave a different alleged onset date. We would have then withdrawn after wasting our time appealing to the ALJ because we didn't have the file and couldn't see this earlier. We would then have to request to withdraw the request of hearing and submit it to a judge. And the judge and his clerk or whoever would have to take the time to review it and presumably grant it. But nonetheless, in the meantime, they're getting the claimant's file as if it's going to be getting ready for hearing. They're doing all this stuff, and then reviewing a request to withdraw a request for hearing, because now we know, because once we filed the request for the hearing in short order, we were able now to see what the field office wouldn't provide us down below. So all this different wasteful time is going on. And yes, granted, I understand some might say, well, who cares if you waste the attorney's time? I get that, totally fine. I happen to be a real advocate for taxpayer monies. And not to mention, it's part of the Social Security fund monies that go towards administrative expenses. So all of this waste is wasting taxpayer money. It's wasting Social Security funds that should be used on other things, all because they wanted to send me a $40 bill. A $40 bill. First of all, I'm not paying it. It's always going to be the claimant. Always. So, according to their own narrative on their in their palms, he's entitled to a free copy. We pointed that out to them right in the request. So there's no excuse of ignorance. I get they're untrained and some of them are pretty new and might not know, but that's a crying shame. But we put the details right in there because I expect them to be untrained. I don't have any high expectations for high training, not in this day and age when half the people are very new. A lot of people didn't come back to work. A lot of people don't want to work, and they have a high turnover rate. So we expect to have, freshmen in there, guppies, as you will. So I just watched a movie it was called The Circle on Netflix last night. And Tom Hanks, who plays a CEO or something of some very, a company that seems akin to a big, huge tech company out of Silicon Valley. He calls the newbies in his company guppies. Anyway, we expect that. So we kind of go out of our way to explain what they should be doing. And they couldn't follow those instructions very well. So here's what we got. So they got slapped back. And I was tempted to send a complaint to the OIG. They have a page. I'll try to attach it here if I can locate it on a button in the end, where you can report, I can talk, fraud, abuse, waste. I think the original intention was that people could report fraud from outside people. Maybe they know a claimant who's committing fraud, and that's all well and good. But I do see they do indicate that you can talk about staffers doing something wrong. Now, in this case, it's not a staffer defrauding anybody. It's just being wasteful. And if they talk about waste, fraud, abuse, I would say it's wasteful and abusive. So I was tempted, and I might still, if I don't hear something kind and favorable. And by the way, I did tell them that I already have access to the file now that we finally had to appeal. And if we determine we have to now withdraw that appeal, that'll be more wasted money on your hands, SSA office. But so I did let them know so they don't go ahead and email it or put it together or whatever they're going to do. I think they can email it. There's an email, there's a fax, a million and one ways they can do it without costing any money besides the few minutes it would take a staffer to send it. So what's it going to cost? $5? I don't know. Something low though, clearly. So I did tell them that because I don't want them wasting any more time, but they need to know that this is not acceptable. And I want to hear back. I want to hear, yes, we understand that that was an appropriate letter, that we should not be trying to charge $40. Because the second they think they can start doing that, they're going to start. This happens all the time in other venues in life. Once they don't get a spanking for it, why not continue sending out letters demanding $40 to everybody? Some of them are going to pan out. People are unaware and they're desperate for their file. So there goes a $40 fee that's not even legal. So anyway, this is my vent. And it was just ironic because James had just put out this question this morning. And here I get this letter today. So wanted to put it out. So I did smack them down to the best of my ability while still being hopefully respectful. And that's what I try to do on occasion. It takes up time though. You know, it could have been an hour out of my day or 2 hours out of my day. And I, believe it or not, I work a ton of hours. It's ridiculous. So anyway, I just wanted to share that with you, and I will chat with you guys next time. Bye now.